A very practical session. Wills and estate planning. Lots of people make lots of mistakes because they think once when you're dead and gone, the mistakes are buried with you. Setting up a trust, you've done that. How important it is to link your trust to your will. No point in having a trust when you can't link it to your will. And you would hate to draw up a will, and if you can read that, I'm not sure whether you can. It says, I, being of unsound mind, hereby bequeath 40% of my estate to the taxman. Yes, you can do that. If you don't plan properly, that's what you'll end up doing. As far as marriages are concerned, in South Africa, we're governed by a whole lot of new acts that have come out now. But by and large, we're governed by the Matrimonial Property Act of 1984. And this act says, in principle, you can have two types of marriages. You can have an in-community or property marriage, or you can have an anti-nuptial contract. In an in-community or property marriage, it is a joint estate. Husband and wife put their assets into a common pot, and ultimately, when that marriage ends, it gets dissolved to either divorce or death, the assets are shared equally between the spouses. So it's a very simplistic way, but you have to formally arrange your marriage. You have to have a marriage officer, and you have to formally register your marriage for you to be an in-community or property. You could have those customary marriages and so on. I don't want to go into a lot of detail, but you can formalize those. But not all the provisions of the law apply to those kind of marriages. Out of community or property marriage, you can either have one with the accrual system, or they say the accrual system automatically applies, or you can specifically exclude the accrual. Now, what is the accrual? The accrual regards the marriage as a partnership, and all assets acquired during the subsistence of the marriage be shared equally between the spouses. So if, for example, the wife stayed at home, had the children, looked after them, and did whatever was necessary, and never amassed a wealth, and the husband did all the work, and he had all the assets in his name, yes, it is an antinuptial marriage. There is a separation of assets on different names. But any assets that were acquired during the marriage would have to be counted for and be divided between the spouses. So in my example, if the husband has all the assets, and if he dies, he has to then pass over in his estate. When we do the accrual calculation, half of the assets are acquired. So if in total the wife did acquire a small amount of assets, the husband a great number of assets, it's added together, and let's say if it arrives at 500, you divide it by 2, and it's 250 each. If the husband's got 400, then he has to part with 150 and pass that over to the wife. So the calculation would have to be done in terms of the accrual system to establish what the accrual was. You have to declare in your ANC, as you know, those of you who have done this kind of marriage, you have to declare your assets in the case of an accrual system, what your assets were at the time you entered the marriage. So those are excluded. Inheritances and gifts are actually also excluded, but let's not go into detail. Without accrual, it means that where you specifically want to exclude the accrual system, where you don't want the accrual system to apply to your marriage, you may have to state that in your antenuptial contract. The person who's drawing up the contract is obligated to discuss that with both spouses, and both spouses must understand what that means, because if that is not explained, then the aggrieved spouse can go to court and argue that that aspect of the accrual was not explained, on that basis that the without accrual marriage be set aside. Okay, we have to do the accrual calculation at some time, either due to divorce or death, which means the termination of the marriage, and that calculation then will then count. The use of trust in marriages, many people form trusts after they get married, and they start dumping assets into trusts individually, so that they keep the assets away from themselves and they don't have to account for it in terms of the accrual. You could do that, but your trusts have to be proper. Okay, as far as wills are concerned, you can either die interstate, or in terms of the law of succession rather, you can die interstate or you can die testate. If you died testate, it means you died with a valid will. All the provisions of the Wills Act applies to the will that you have, you attested it properly and so on. If you die interstate, it means you don't have a will. If you die testate, that means with a valid will, it means that you have a set of instructions in your will, and the will is legitimate, and the executor who gets appointed has to follow the provisions of the will. The overarching authority for this is the Master of the High Court. The Master of the High Court looks at the will, looks at the executor, ensures that the executor distributes the assets after payment of all the liabilities to the heirs, and then ensures that the estate is finally shut down. If you die without a will, there are no instructions, because you haven't left any instructions. The executor must follow the law of interstate succession. It makes your estate complicated, and undoubtedly it can be long-winded, and that can create problems for you and your family. So your last will, it's important, it's your last document, it's the most important document you're going to draw up in your lifetime. It's generally drawn up by people over the age of 16 rather, who would have assets, who understand what that means. Written document by a competent drafter, I think that's also important, the key word there being a competent drafter, and we're going to talk about that. Testator's signature on each page, that is what I'd like to see. They speak about, you could have initials on each page. Will should be dated. Will need not be dated, but I believe it has to be, because in your will you say that this is my last will and testament of me, and you also say I cancel and annul and make void all previous wills. You can't have 6 wills and now you haven't dated it, now you want to try and work out which is your last will. So therefore I think the dating is important. Attested by 2 competent witnesses, because remember you can sign a will today and change it tomorrow morning. It's the date that counts. If you do 2 wills on the same day, well, you've got to put the times down. Attested by 2 competent witnesses. The word is emphasis on competent. The witnesses cannot act as executor or benefit from a will. If you buy the Adams Stationers one, quite often people get caught out with this aspect where they sign the will, but the witness happens to be the surviving spouse. Now that kind of will means that she's a beneficiary of the will, she is perhaps the executor as well. She cannot act as an executor or act as a beneficiary purely because she's a witness to the will. What then happens, the master will not accept that. You have to go to court and prove that you did not unduly place influence rather, the testator when he or she was signing the will. So it just lengthens the process, it adds to the costs. Your last will and testament is a written document, it's a set of instructions that you're passing on for the distribution of your assets. I think what is most important is it's a tie-up of trust assets, personal assets, insurance to your will. And these are individual things. Often people, high net worth people, want to get their wills drafted. They go to people, and the person who's drafting the will doesn't even ask them, I'm a high net worth people. What is high net worth? Oh, I've got 50 million rand of assets. Can you please draft my will? Oh, okay, let's just keep it simple. What we'll do is that we'll take your assets, we'll pass it over to your surviving spouse, and then let her then make the decision at some later point in life. It doesn't make sense. You're a high net worth person. You need to work out what you own and what you owe. Who are your beneficiaries? Identify them. How do you propose, for example, paying off your liabilities? What is your insurance? Who are the nominated beneficiaries in your insurance? Do you have a trust? What are assets lying in the trust? Remember, you can't bring those in. Do you have a formal letter of wishes to instruct your trustees to follow certain rules and regulations in your view, which are called the letter of wishes? Again, that is not legally binding, perhaps morally binding upon those trustees to follow your wishes, because you say, if I was personally present, this is what I would have done. This is how I would have done my distribution in my trust. So that is a document of a letter of wishes that you would draw. If you have minor children, in the case of a simultaneous death, how important is the guardianship? How important is for you to understand it is not possible for you to nominate guardians. For example, people tell me it should be my brother and my wife's sister to be the guardian. What is guardians? Guardians are people who act as parents. How can you have a child who is 5 years or 8 years old that is going to a school? You have the guardianship half with somebody that lives in Joburg, the other half that somebody lives in Durban. How is that possible? But people actually do that. There could be different religious beliefs. There could be all this. Remember, as a guardian, you step into the shoes of the parent. You're supposed to take the child to school, view all the aspects in terms of educational aspects, go to the school meetings, do all of those things. That is why I believe it's very important, if you appoint guardians, that you speak to them beforehand and you tell them that you're appointing them as guardians for the children. And it must be a person that can jointly look after that particular child. And don't split children between families. I often see that as well, that my brother will look after that child, my sister will look after this child. It doesn't make sense. Now, these are important things that people don't carefully consider. But the trusteeship in the case of guardians is important because as a trustee, you taking into account the money aspect. You are providing, if the guardian says, I want 20 grand a month to support this child, you as a trustee in terms of the trust have to provide that money. That 20,000 rand a month needs to be deposited into the guardian's account all the time, each month. You've got to make sure that you have left sufficient capital which then invested will then provide for the income of the family, the lifestyle of the children and your family in that case. Islamic wills are, in my view, difficult to manage from an estate planning point of view, but if you are doing these kind of wills, then remember you have trusts and you can clearly pass the assets into the trust, and then when you die, you can leave a letter of wishes that will then instruct the trustees to follow Islamic tenets or Sharia law to make sure that it reaches the beneficiaries in terms of Sharia law. Tax and estate planning again becomes crucial. Shifting assets into trust, which we've discussed, using surviving spouses deduction, which means that if you're a high net worth person, you can pass on your assets to your wife, let's say if you're the husband, and then effectively what happens is that whatever assets you pass on to your wife, the estate duty and the capital gains tax gets postponed upon until your wife dies. Yes, the assets will grow in her estate, but why not let the family enjoy that cash flow rather than pay the estate duty upon the first dime? Because the last bullet point here talks about implementing an insurance policy for estate duty. And you do get these policies where you have a joint proposer to the policy, and the policy only pays out upon the last dying spouse. So what it means is that if you pass the assets over to the surviving spouse, only when the surviving spouse dies will the policy be paid out. So therefore your premium should be a lot cheaper because you have two people who are proposers to it and two life assures. And then upon the surviving spouse's death, the policy then gets paid out, and then you then pay the estate duty out of that money. So it makes sense to have that. Making use of usufructory rights. Property has two rights of ownership. They have the bare dominium and they have the usufruct. If you split the two, yes, you can save estate duty. I won't go into a lot of detail. Reduce your loan account as an asset in the estate. Possible to do that. Maximize on the 7 million rand abatement. You can also do that. So as an executor, you have a role. Who should be the executor? Very important consideration. Often people leave the executorship to others, other than immediate family member. And that's not a good thing. I'll explain to you why just now. The executor needs to appoint a competent administrator of the estate. The administrator needs to do the following, and it looks very simple here. All he needs to do is identify the asset, quantify it. So he identifies all the assets of the deceased. It will exclude things like that are in trusts and so on, and he values the asset. He further determines the liabilities and claims. He settles the claims, provided the legitimate claims. The third thing is whatever is then left, he determines who the heirs are, the beneficiaries. He transfers the assets to them and gets a clearance to say they've accepted their inheritance. He can then close up the estate and prepare an L&D account, which he's meant to do over 6 months, report to the Master of the High Court, Bob's your uncle, it's all finished. It may sound very simple here, it's done, and you think it's over. I can tell you that there are estates that are going on for 15, 20, 25, 30 years. Just not wound up. Because it has far too many complications, it has people who are not properly guiding people. And then this is a point I make. On that basis, it's very important to appoint the surviving spouse as the executor of the estate. Because the surviving spouse is a person who should be communicating with the Master of the High Court, signing letters and so on. When you pass on that authority to the administrator doesn't even communicate with the family. This is why estates go on for 5 and 10 and 15 years, because you don't really know what's going on. And you think, anybody asks you, is the estate wound up? Oh yeah, I don't know. Speak to the executor, the administrator. They're handling everything. If the master has a query, that letter goes directly to the administrator. You don't even see it. Perhaps the guy applies for 1 year extension, 2 years extension, 5 years extension. It goes on forever. And you poor person waiting to ensure that things get sorted out. But what is most important is to appoint a competent administrator of the estate. And we'll talk about that just now. The executor and the administrator normally gets a remuneration, which is 3.5% of the gross value of the estate. And he also gets 6% of post-death income of the estate. Now, what about the remuneration? Can it be negotiated? Yes, it can be negotiated. It depends on the nature, the type and value of the assets, the liquidity of the estate. It depends on the complexity of the estate. A lot of people, what happens is that if I take a very simple estate, it's got 10 million rand cash, 3.5% of that gives you 350,000. Of course, it's unfair if an administrator of the estate then takes the one bank account, closes it up, distributes the surviving spouse. Bob's your uncle, he can do it in a day, and effectively charges you 350,000 rand. Perhaps a fair fee would have been 60,000 rand to do the whole thing for you. So the point is that, on the other hand, you could get a very complicated estate, and the master may even approve more than 3.5% if you can justify it. So this whole thing about negotiating that can come about perhaps even before you start, before the person dies. So I normally do that. I sign a letter with my client because I do all the planning up front. I tell the client that you're a high net worth individual. You understand what the estate is all about. You can see what the figure is going to look like. Let's negotiate the rate at 2.5%. I make him sign, and I sign, so that when the beneficiaries then say to me, no, we want the estate to be done at 1%, somebody is prepared to do it at 1%. You put the letter in front of them and you say, look, you signed with your father or your husband or your wife or whoever it is. There it is. We understand what's going on. You want to go somewhere else, that's fine, because you're only nominating an administrator. You're not appointing him in the will. If you want to do that, it's fine. We know what to do. We will wind this thing up very quickly. We'll be able to do it. So you have that situation as well. But I think what is most important is that the administrator must be conversant with the various legislation. There are 12 different acts, and it's not only 12, it could be a lot more. There's a Wills Act, there's the Estate Duty Act, there's the Administration of Estates Act, there's interstate succession, income tax, pension fund, company, close corporation, trust property, divorce, matrimonial property, long-term insurance, maintenance of surviving spouse, and I can go on about a few other acts. It means that you have to be conversant with all of this when you're winding up estates. Otherwise, it makes it very, very difficult to wind up estates. There's a real situation. The Ambani family of India. Those of you may have heard of this family, because this is a family that owns the cricket team, or this Mukesh Ambani owns the team Mumbai Indians in the FPL. This is one of the richest families in the world. It's involved in the business of power and telecommunications called Reliance. It would have been the richest family in the world if it wasn't for one thing. The father was the founder of the business. He died without a will. The legal spat between these two brothers is unbelievable. They don't speak to each other. They only talk in court. And they've literally broken up the entire estate of the father. So therefore, the winding up of the estate, that guy Mukesh Ambani, those of you who have been to Mumbai, probably knows he has a house that is 27 stories tall. He has 8 stories in which he only parks his cars. That's the kind of wealth this man has got. So I wonder what would you do in a 27-story house? We don't know whether you're in floor 5 or floor 15 or floor 25. The winding up of an estate should be smooth, quick, and effective. I think that's important. Hence, it needs the skills of a lawyer, an accountant, financial advisor, a property valuator, a tax advisor. The skills of all of these people rolled up into one. It's very difficult to get this kind of thing, this kind of skill, all being operated by one person. I've tried to specialize in these different areas. It's not very easy, I must say, but it is possible for one person to have all of those skills. And hence, what I have developed myself is what I would call the smart file. And what the smart file is all about, this is in reality, I create a smart file. How often those of you who are in practice meet with a client, a high net worth client, and are busy trying to do an estate plan for them and trying to draw up the will and do all of that. You speak to the client and you tell him, okay, you have his assets and liabilities, you're starting to talk to him, you tell him, do you have any offshore money? He says, yeah, I think so. I think it's at Barclays, I have an X amount, and I think I have certain amounts in some other banks and so on. Now, can you imagine he's thinking about it and he's telling you? Okay, where's all your important documents, your insurance, let's say your marriage contracts, your investment portfolios and all of that? Yeah, I think it's in the office, I think some are lying at home, or it's there, or wherever it is. Now, how important is that If you're asking the guy whilst he's alive, when he dies, you're going to speak to his family. You think his family know where these things are? Do you think his family knows where his offshore accounts are? Do they know where to look? Do you know he's highly successful in his business, all his business secrets? For example, his formula about how he buys properties, if he's in the property game, what he does, how he borrows the money, and so on. If you don't document all of that, you die and you go to the grave with all of that. It's of no use to your family. That's the succession plan partly that we talk about. How important it is to document all of that and keep it in one file. How important it is to know who the banker is, who the financial advisor is, who the lawyer is, to the point of doing a document to say, that is the person, that is his contact details, his email address, his telephone number, his postal address, his telephone numbers, everything, all sitting in one document. So when the person dies, I get handed the file. And within 2 days, all the letters go out to all the companies to say, we want, to the auditor, get the valuations done, we're giving you a month. To the bank, 4 banks, within 14 days, we want the balance at the date of death, we want to know what was the capital. You know how quickly that estate gets wound up? Now those are the critical issues that sadly get left out. And then, remember, this is a true cycle that you have in these families. There is a mourning period. You call them 15 days after the person has died. They are highly cooperative with you. They're emotionally charged. Agree, they're in mourning. But you give them a list, and that's what I do. I have a standard typed out list at the first meeting. Tell them these are the 15 things I want. Perhaps the first 8 things in 14 days' time, we're meeting again. We want it on our table. If you've got a problem with it, you contact our officers and we will help you through the process. And you break it up. You find that in the first 3 months, they're highly cooperative with you. In the 5th month, you ask them for information, they'll take 6 months before they bring it to you. Sadly, that's a cycle that operates, and you need to ensure. So if you have a file like this, and this file obviously needs to be annually reviewed, and that's what I do. It needs to be annually reviewed and updated. So if they change the bankers, you have the up-to-date insurance policies on file, you have everything in one place, and all you do, most important is you keep it in a locked vault. Because it's amazing, and I've come across the situation where people die and the will gets destroyed. Why? Because the surviving spouse has read the will, she's not there, let's just burn this will. We don't need it. 3 hours after the guy's body is still cooling off, the will's disappeared. It's burnt.